Welcome. I call to order this special meeting and executive session of the Scottsdale Unified District Governing Board. The date is Friday, April 6, 2018. The time is 4:02. We will start with a roll call from my far right.
Sandy Kravitz.
Allison Beckham.
Pam Kirby.
Barbara Perleverd. Board Member Hartman is on her way in and will join us, so we will have a full board, and we do have a quorum. Can we please stand for the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. So I will note first that we will be tabling agenda item 3B until such time that the board determines it is necessary. And at this time, I'll make a motion that the board adjourn into executive session for agenda item 3A pursuant to ARS section 38-431.03A3 and A4, discussion or consultation with the governing board's attorneys for legal advice, and in order to consider its position and instruct its attorneys regarding the public body's position on administrator contracts that are the subject of negotiations, in pending or contemplated litigation or in settlement discussions conducted in order to avoid or resolve litigation. Superintendent, Chief Business and Operations Officer. The attorneys may appear in person or telephonically. Do I have a second?
Second.
Thank you, Board Member Beckham. All in favor?
Aye.
Aye. Motion passes 5-0. We will adjourn the executive session. Sorry. Back, everyone. The time is 6:25, and the governing board is reconvened in its special meeting. At this time, before we move to action items 4A and B, possible approval of severance agreement with superintendent and possible approval of severance agreement with chief business and operations officer, I would like to make a motion that the board waive the attorney-client privilege to allow counsel to discuss the reasons for recommending approval of the severance agreements. Do I have a second?
Second.
Thank you, Board Member Hartman. All in favor?
Aye.
Aye. Motion passes 5-0. Mr. Sanas, would you like to present to the board this evening? Thank you.
President Perleberg, Vice President Hartman, members of the board. My name is Joel Sanas. I'm an attorney at Udall-Shumway. And this evening, presented for your possible approval is a severance agreement between Scottsdale Unified School District and Dr. Denise Birdwell, and a severance agreement between the district and Mr. Lewis Hartwell. With the board's permission, I would like to share the reasons that we are recommending that the board approve the agreements and to answer questions that the board members and the public might have. I'll present the information in a question and answer format because I think that will be a helpful way for you to receive this information. The first question is, why must the district go through a hearing process to dismiss the administrators? The answer to that is that under Arizona law, and also pursuant to the administrators' contracts, the administrators are entitled to receive the same full-blown due process procedural rights that teachers have. This means that they are entitled to an evidentiary hearing, and timelines for the hearing process and other aspects of the dismissal process are set forth in statute adopted by the Arizona legislature, and those statutes for reference are Arizona Revised Statute Section 15-541A22 and Sections 15-539 through 543. It also means that administrators also, like teachers who request our hearing, are paid their salaries and benefits until the hearing ends. The hearing officer makes his or her recommendations, and the hearing is transcribed. Then the board reads the transcript. The board meets and votes to either agree or disagree with the hearing officer. This requirement that administrators be paid during this hearing process is also a requirement that the legislature has adopted, and that's Arizona Revised Statute 15-539F. In our circumstances, Mr. Hartwell has already requested a hearing. Dr. Birdwell has not yet requested a hearing, and her deadline to do so is Monday, April 9th. Based on conversations with Dr. Birdwell's counsel, who is also Mr. Hartwell's counsel, we're confident that Dr. Birdwell is also going to request a hearing. The next question is, if these matters are not resolved through severance agreements, what is the estimated time frame for the proceedings to be completed? Having already discussed that the administrators will be paid all of their salary and benefits through the time the hearing is completed, it's important to know how long it will take to complete this process. For us, the most realistic estimate is that the proceedings would be completed in 2 to 2.5 months for Mr. Hartwell, and between 2.5 and 3 months for Dr. Birdwell. Again, pending that final determination, the administrators must be paid their regular salary and benefits. There is a rule in the procedural rules that the hearings are supposed to take place no less than 15 and no more than 30 days, but there are practicalities involving the availability of counsel, the availability of the hearing officer, and in our case, the availability of several witnesses who would be very important to establish the bases for these statements of charges against both of the administrators. So although we have that 15 to 30 day period, practically it is not likely that we'd be able to complete the hearings within that 30-day period. Following the final administrative decision, the employees could file an appeal in Superior Court, which could take many months to conclude. The administrator's right to receive payment under statute would be concluded after the board adopts the a recommendation of a hearing officer to accept the statement of charges and to allow dismissal, but they would still have a right to appeal to the Superior Court after that point. So the third question that we thought was important to address with the board is it fiscally, economically prudent and in keeping with the board's fiduciary responsibilities to resolve these employment matters through the proposed severance agreements? We're answering that question yes, as counsel, and I will address each of the severance agreements in turn. For Dr. Birdwell, the total value remaining on Dr. Birdwell's current contract, which extends through June 30th of 2019, is over $447,000. The severance agreements, which you have in front of you, that have been signed by Dr. Birdwell and Lewis Hartwell, have not yet been signed by the board, of course, because the board has not yet approved the agreements and has to deliberate regarding whether it is going to approve the agreements. The severance agreement for Dr. Birdwell provides for a payment of $150,000. So about a little bit more than 1/3 of what the total contract value is through June of 2019. If the district proceeds to a hearing, it will continue to incur the expenses associated with paying Dr. Birdwell her full salary and benefits, which will cost a minimum of $69,000 based on the numbers that we have, and could cost over $120,000 if the proceedings were not to conclude before June 30th of 2018. In addition to paying the salary and benefits over that period, the district has some direct costs to go to the hearing that would be payable from the maintenance and operation budget. And that number is likely to be in the $30,000 to $40,000 range and could possibly be more. This includes costs to the district associated with the following: 3 to 4 days of a hearing plus pretrial hearings with the hearing officer. That's the hearing officer's fees. Attorney's fees for an attorney to represent the board. There would be a separate attorney representing the board in the hearing process. That attorney should be different than our law firm, so to avoid a potential due process objection. In other words, the attorney who would be representing the board in the hearing process should not be the same law firm that is representing the district in pursuing the dismissal process. There would also be fees for the hearing officer, subpoena service of process fees, witness fees, court reporter fees, copying costs for evidence, costs of the transcript, possible expert witness fees, which could be expensive, and time of employees who will testify. And there would be a number of district employees who would be necessary as witnesses at the hearings. In addition to the monetary expenditures that would come directly from the M&O funds, the district's insurance rates might be raised for next fiscal year based on the district's attorney's fees usage for these hearings, which are expected to be in the range of $30,000 to $40,000. And again, those are estimates only. It is possible they could be lower. It's not likely. It is more likely they could be higher based on the actions of Dr. Birdwell and Mr. Hartwell in contesting the hearing. Those numbers do not count the potential costs of an appeal to Superior Court. And of course, these are estimates only, and these types of proceedings can be unpredictable, but it gives an idea of what the economics are in pursuing a hearing with Dr. Birdwell. As to Mr. Hartwell, the total remaining value on Mr. Hartwell's contract, which runs through June of this year, is $57,602. These numbers, of course, include not only their wages and salaries, but like any employer, the district also pays FICA, the employer's share of taxes. It also pays contributions to the state retirement fund. So these numbers I should explain, these numbers do not simply include what their wages and salaries are. Like any employer, the district has to pay substantial costs of employment beyond wages and salary, and all of those things would need to be continued to be paid until the hearing process is concluded. The severance agreement for Mr. Hartwell, again, his total payout is $57,602. The signed severance agreement that Mr. Hartwell has agreed to provides for a payment of $30,000. If the district proceeds to a hearing, Mr. Hartwell will continue to incur the expenses associated with his contract, which means that it will likely pay Mr. Hartwell most, if not all, of the balance remaining on his contract. It wouldn't be surprising that Mr. Hartwell would have as a tactic and a strategy to delay the hearing process as long as he can, because the longer he can delay it, the more likely it is that he would be paid the full value of his contract. Hypothetically, if he could delay the hearing process through June of 2018, he would be paid the full value of his contract, $57,000, as opposed to the severance payment of $30,000. The district's direct cost to go to hearing, payable from M&O, the budget, is likely for Mr. Hartwell to be in the $14,000 to $20,000 range. In addition to the monetary expenditures that would come from M&O funds, like Dr. Birdwell's case, the district's insurance rates might be raised for next fiscal year based upon the district's attorney fee usage for these hearings. Thus, it would cost the district much more to proceed to hearing than it would cost to resolve Mr. Hartwell's dismissal through a severance agreement. The next question is, are there other advantages of resolving these matters through a severance agreement rather than a hearing? And as counsel to the district, we have concluded the answer to that is also yes. Let me give you some examples. Detracting from the focus on mission and students. All of the following points would be a distraction from the mission of the district to engage, educate, and empower every student every day. The next is responsibility of the district. The statement of charges against the employees pertain to alleged violation of the district's policies and administrative regulations and civil rules relating to procurement. The only matter of which the district has control right now is the matter of their continued employment with the district. Next is timeliness. The matters can be resolved today, which will allow the district to move forward and begin the search process for a new superintendent. The agreement with Dr. Birdwell will allow the district to move forward and initiate a new search for a superintendent, a process that could be delayed by potentially drawn-out proceedings. The next, and this is a consideration with any case where there are disputes, is certainty of outcome. The district will avoid the risks associated with the possibility of losing the cases at hearing or on appeal. There is no guaranteed outcome despite how strong the district position is on the statement of charges. And we presented the statement of charges at the board hearing and believe that we have a very strong position on the statement of charges. But there is just no way to guarantee the outcome, and there is also no way to account for the costs of any counterclaims that might be brought by the administrators. The next, related to counterclaims that may be brought by the administrators, is a waiver and release of claims. The agreement that you have, that the administrators have signed, contains a complete, full waiver of all claims, known and unknown, suspected or unsuspected, to date. So it would give the district the certainty that no counterclaims could be brought against the district by the administrators. A next consideration, which is non-monetary but should be considered, is staff time and attention to district operations. Staff will be able to focus their time and attention on their work rather than preparing for and participating in the hearing. Staff will be spared the undue stress of being put through a hearing and cross-examined. As an attorney, I can tell you that it is no fun to be cross-examined in a hearing, and your staff will be necessary witnesses at the hearing. And settling with the severance agreements will protect your staff from having to be participants as witnesses going through cross-examination at the hearing. So in that way, resolving the matter will conserve district resources and also preserve the morale of staff who might be involved in the hearing process. The next question is, what impact does settling or not settling today have on the district's ability to hire an interim superintendent and begin a superintendent search? As I've already mentioned, the sooner the matters are resolved, the sooner the district can act to appoint a new interim superintendent if needed and begin the search process for a new superintendent. Next question. What impact, if any, will the severance agreements have on the employee's ability to receive their state retirement benefits? There is no impact upon the employee's ability to receive state retirement benefits, whether the employees are terminated through a dismissal proceeding or whether their employment is severed through the severance agreements. Forfeiture of public retirement system benefits is addressed in ARS Section 13-713. Under that statute, a public employee that is convicted of or pleads no contest to a Class 1, 2, 3, 4, or 5 felony and that was committed in the course of their public employment can have those benefits forfeited. However, the employer has no role whatsoever in a forfeiture action, and in our case, nothing that happens in the hearing can affect whether the employees and the administrators, might be subject to a felony prosecution that could affect their retirement benefits. Some final considerations, board members, to the district's knowledge, and to our knowledge, Dr. Birdwell has not been charged with criminal conduct or wrongdoing to date. The district has no way of knowing if or when that will occur in the future. If the Attorney General chooses to bring a criminal prosecution, that is not within the district's control. It is within the control of the Attorney General, both if and when the Attorney General might bring any form of criminal charges in these matters. Next is, the statement of charges against the employees pertain to alleged violations of the district's policies and administrative regulations and civil rules relating to procurement, as I've already mentioned. And again, the district has no control right now over any criminal actions, and the only thing that the district can control is these administrators' continued employment with the district. As I mentioned, the administrators will release have signed an agreement that releases the district from any claims they have to date, whether they know about them or don't know about them, suspect them or don't suspect them. The administrators have asked the district to give them the same release. The agreement that you have in front of you does give them that same release. So the agreement you have in front of you will result in a waiver of any claims that the district might not know about to date or that it might suspect about or not suspect about. It is a global release that is effective as of the date that the agreement is executed. However, I want to make this point. We have negotiated an agreement that says that the severance agreements do not prohibit, restrict, or otherwise impede the district's ability to make required reports or cooperate as needed with any state or federal authorities' investigation in these matters. The district has and will continue to cooperate with the Attorney General's office. Last is an important consideration that the severance agreements do not contain any confidentiality provisions, nor do they contain any non-disparagement provisions. Our position is that economics justify the settlement. Attorneys are focused on objective economics. From the very largest cases to the smallest cases, justice and fairness is almost always an issue. As attorneys, we focus on the economics only because those are the things that we can control. And because the economics favor these severance agreements, that is why we are recommending that the board approve the agreements. Thank you for taking the time to listen to me.
Thank you, Mr. Sanas. This time, do we have any questions or comments from the board? At this time? Yes, Board Member Beckham?
I'll just thank you for outlining a lot of the reasons. I had made a list and a lot of them were in there also, so I know you've done a thorough job, and I appreciate the time that you've put in and the ability to answer all the questions we had from a legal standpoint, especially from me. Thank you.
I'd like to echo that sentiment. Thank you for all the hard work and this very thorough assessment of our options. Board Member Hartman?
Likewise, Mr. Janice, thank you for your work on this. It's important work, and we appreciate your time and talent. I did have a question for you regarding the AG office.
Yes.
Obviously, we have no control over how they pursue this and the timeline. However, if they do identify and decide to pursue some type of criminal claim or something to that effect, and there are financial implications, do we as a district have the opportunity to participate in any restitution or recovery of any funds?
No, if the restitution is something that's available under Arizona law to victims of criminal activity, and if there is an economic impact to the district from any criminal activity that the Attorney General is prosecuting, the district can ask to be listed as a victim, and if there is a basis for restitution, the district would be entitled to restitution. And it's often the case that during criminal investigations, if there is any form of plea bargain, restitution can be made a requirement of any plea bargain.
Thank you.
Board Member Kirby?
Two questions. First one, is that also true for civil or just criminal?
If there were civil actions brought by the Attorney General against the administrators, the Attorney General could make a requirement of settling its civil action that the administrators provide compensation for any impact that their actions have had to the district. So yes, it's also true of civil. Although if the Attorney General has a claim against the administrators of a civil nature, and it is to the benefit of the state, and the state were to win, that would be money that would be paid to the state. But again, as part of a settlement, the Attorney General could require, if there is any need, if the Attorney General feels there's a need for reimbursement in the district, as a part of a settlement, it can ask the administrators to repay the district for any economic impact it's had.
Thank you. And then my second question is, if the Attorney General's office does have findings, but for whatever reason chooses not to pursue, under this settlement agreement, can the district pursue those claims?
I don't believe so, because of the nature of the release.
Thank you.
If we know about the claims, whether we know about the claims or not, if those claims have their factual basis before today, then the district would not have any ability to bring an action on its own, whether it knows about those claims now or not.
Thank you.
I will say that we also have done a very thorough investigation. It's possible that there are claims we don't know about between Attorney Susan Siegel's investigation and the investigation we did to assist the board in preparing the statement of charges. We think we've covered everything, but I wish we could say we know for sure, but we think, at least we can say it's been a very, very thorough investigation.
I'll ask the question then. If that is the case, though, if this district wanted to, or found reason to try and bring a case for itself to these individuals, that would obviously be a cost to us, I mean, if something were to be found in the future that we thought the district had a claim, and it wasn't something the Attorney General's office was going to pursue, it would then be our cost to pursue such a claim. Is that
I'm assuming if the district did not enter into the severance agreements and then found that it had claims that wanted to pursue it as a civil nature, yes, it would be the district's expense to pursue those claims. And we've given you
it's risk.
It would be at the district's risk. We've given you the numbers for what the potential cost will be to go through the dismissal proceedings under the statements of charges. If the district were to pursue a civil claim in civil court, I can tell you those costs would be much, much higher.
Okay, thank you. Board Member Kravitz?
And those costs would be from maintenance and operations budget?
Yes,
Okay.
I believe so. Now that I'm going to say yes to that, but I heard at the last meeting I'm not a fiscal expert, and I will also say the same thing.
Board Member Kirby?
Another on this topic, and you did say it in your opening statements, but I'd like to highlight for clarity purposes. the waiver of claims that we're discussing is section 4B in the settlement agreement. Can
Yes.
you again state how section 4B was put into the settlement agreement?
We had drafted a severance agreement that we provided to counsel for Dr. Birdwell and Mr. Hartwell. And the original settlement agreement only had the section 4A release, which was Birdwell's and Hartwell's release of the district from any and all claims, known or unknown, suspected or unsuspected. As often happens in discussions to resolve an issue, we had the message of, if the district gets this release, then the administrators want the same release. And that's why you'll see that the language really tracks, the language is the same. Dr. Birdwell and Mr. Hartwell released the district from any claims known or unknown, suspected or unsuspected as of the date of the agreements. And once we made that point, it was easy to cut and paste and put that into their subsection B that says that the district does the same with them. And it's a common discussion in settlements that both parties want the same types of releases. It's also fairly common to have a release of claims known and unknown, suspected or unsuspected, because in cases where there is a dispute, there becomes a difference in trust, and nobody wants to be exposed to any potential claim, good or bad. And so that's the type of language that says, it doesn't matter if you have a good claim or a bad claim, you knew about it or you didn't know about it, you're releasing it, which lets the parties move on without worrying about other claims being brought in the future.
Thank you, Board Member Kirby.
One last question for me, and similar to that paragraph, were there any other provisions in the settlement agreement that were requested by either Dr. Birdwell or Liz Hartwell?
You know, the other requests were mostly, I would say, non-substantive. One of them was, we had a discussion of, again, Dr. Birdwell's ultimate payout could be $447,000. We're settling, if the agreement's accepted, for $150,000. There was a question about whether they would get what I'm calling it their last paycheck. The school district, like any other employer, most other employers, pays in arrears. So it would be $150,000 plus their last paycheck. And that was one of the things that they asked for. I would call that mostly a clarifying issue. If that hadn't been clarified, we probably would have had an argument later about whether they get their last paycheck. And the other issue was, there is a provision in the agreement that we suggested that says that Dr. Birdwell and Mr. Hartwell will not have any contact with district employees, will not be on district property without permission of the general counsel for the district. And we had that forever, and they asked that that be changed to 6 months. And in the agreement that you have, we did change it to 6 months. What I thought of is the reason, I don't know why, we didn't have any discussion about why that was. I assumed that because it includes district property, an agreement like that would prevent either of them from going to a graduation ceremony of a friend or family member. So I assume that it might be because they may someday want to be on district property at a graduation ceremony. They may have acquaintances in the district that they want to contact. They can't contact for 6 months, and they can't be on district property for 6 months. But those are the only negotiated provisions: the release, the last paycheck issue, and 6 months instead of in perpetuity, no contact, no location on the premises.
Thank you.
Board Member Hartman.
Mr. Sands, I'd like to just talk a little bit, you stressed the economics of this quite a bit. I just want to make sure the, very clear on the math and then the additional potential components. So in the case of Dr. Birdwell, we had talked that there is somewhere between, it was between 100 and 160,000 potential cost if just the clock ticks.
Yes.
Along with the case.
Yes.
And the settlement's for 150, so
Yes. more
or less a break even on that.
That's the way we see it, yes.
And
We,
then-
you know, I often tell my clients that attorneys care about justice, but what we really care about is giving good return for investment on your legal dollars. And in this case, it's hard to justify a return on investment on legal dollars. There may be a justice component, there may be a fairness component, but as your attorneys, we're focused on what the economic resolution is, and it's really hard to see an economic resolution that's better than these settlements.
And can I just carry that just a little bit further, just for clarity? And on Mr. Hartwell's situation, if the clock ticks and we go through the process, it's $60,000, as opposed to, and actually the legal fees, so it'd be $80,000 versus $30,000 in his settlement.
Yes, it's possible that we could invest in the hearing, preparing in the hearing, spending legal fees, incurring other costs, and although I don't think it's likely, but I cannot rule it out, we could do all of that, and somehow because of circumstances that we can't control, we couldn't get to the hearing before June 30th. And conclude the hearing, get the decision, have the board approve it before June 30th. So we could spend money, and all that time, Mr. Hartwell would be collecting his paycheck and all of his benefits, and we could, the clock could run out on us.
So I just want to add to that. So economically, it behooves us to move forward with this. So let's play out, we go through the legal process, we let the clock tick, we invest in this process, and let's just say we win. Let's just say we win, that we find that the claims have judgment. Is there anything that prevents a counterclaim back from Dr. Birdwell or Mr. Hartwell to us? Yeah.
First of all, another thing that we tell our clients is you can sue anybody for anything. You don't have to have a good reason. There's a difference between a good lawsuit and a bad lawsuit. We don't know of any counterclaims that they would have, but they're, for example, they are both within the range of counterclaims for age discrimination lawsuits, so that's a possibility. I could think of good attorneys are pretty good at speculating about what counterclaims they could bring. There could be a defamation claim. There could be a claim for intentional interference with contract. I've seen all sorts of claims in my career, good and bad, and whether they're good or bad, it's still expensive to defend them.
Exactly, whether they're frivolous or not, I would say. I've had experience with that.
Yes.
It still takes time and energy and money. Yeah. And then let's play it one last scenario. Let's say for some reason we do not prevail in this process. Would we still be responsible for the $457,000 and the potential $60,000 for Mr. Hartwell, so another $500,000?
Yeah, you're talking about really worst case scenario. If we
Yeah.
go through this entire process, spend all of those funds and have insurance spend part of the funds that are being paid for attorney's fees, and we don't prevail, then yes, you would have to buy out their contracts at full value, or let them stay on administrative leave with pay until the end of their contracts.
All right, thank you.
You're welcome.
Thank you. Any additional questions?
Okay, thank you.
Okay, thank you. So we will move directly to the action item 4A, possible approval of severance agreement for the superintendent, or with superintendent. At this time, do I have a motion? I will make a motion that the governing board approve the severance agreement with superintendent as presented. Do I have a second?
I'll second.
Thank you, Board Member Hartman.
I request a roll call vote, please.
We'll have a roll call vote. Each individual board member will state their vote and potential reason. Board Member Kravitz, would you like to start?
I vote in favor of the severance agreement for the reasons as outlined by our legal, as outlined by our attorneys.
Thank you. Board Member Beckham?
I'm having a real hard time with this. I've gone through, like I mentioned, and went through the pros, the cons, the economics, which I tend to lean towards. And I won't bore you with going back over them, but as I weigh the facts, I just want to express personally that I would also like to see justice. However, I've learned justice comes in many forms, and not always the ones that feel the best. And possibly the justice here may need to be pursued by the AG's office. As I say that, I want to take the time to say that no matter what the outcome is here tonight, I truly believe that there needs to be some vital changes taking place at this district. And I'd like to take the opportunity just to say a few of them. First of all, I think that we need to reinstate leadership in our administrators, our principals, and our teachers. As a board and administration, we cannot continue to do business as usual. We must take the time and the talent that we have, thank you, to review, plan, and prepare, which I don't think this organization and this board maybe has done in the past, and I am guilty of that. Because we need to educate our students for the future. I know that we've talked about auditing, procurement, and HR, and I think we need to add finance departments to that. I know some of this is underway, but I think that we need to, if we're going to move this district forward, we need to do that sooner than later, and that we need to show this community that we're serious about it. I think for finance, we must review each expenditure and confirm its validity. I believe maybe that we need to implement a zero-based budgeting strategy and a method for this school budget. I know this may not be possible given the regulations and compliance we have by the state to get this done by June, but I believe that we could start a process and that we could get 2 or 3 areas, possibly procurement and HR, done at that time, and that we can show our community that we're actually serious about moving this district forward and making changes that we need to. Because one of the things that this has shown is that we have a lot of holes, some mismanagement, some leadership issues, and as a board, we need to step up into the leadership that we need to do, which I realize we are there to govern and set policy, which brings me to the fact that I think as a board, we need to review each and every one of our policies, and we need to make that commitment. Because some of these policies, as we learn as we go along, are either outdated or they're just not effective. They might have been written, but we didn't maybe think about all of the ramifications of them. I personally would really like to see policy BEDBA, which is the agenda preparation and dissemination of information, reviewed immediately, because I believe that it has been short-sighted and it always seems to be that we are at the last minute reviewing things, hearing what we're voting on, and I don't want to see that happen in the future. I am going to vote for that severance package because I do believe in the economics of the payout compared to the possible risks. It doesn't mean that there's a lot that still could be discovered, and believe me, I would like to go through with the process, but I don't believe it is in the best interest of our students and our parents in this community, even if it might be in the best interest of what I would like to do. That's all I have to say. Thank you.
Board Member Kirby? So I'm going to read my statement. In the interest of time, I'll read it once, but it applies to both Dr. Birdwell and Mr. Hartwell. Although I believe it is time for Dr. Birdwell and Mr. Hartwell to go, I cannot, in good conscience, support the settlement agreement before me. I appreciate the intent to move beyond the controversy and move forward. However, verbiage in the settlement document inserted at the request of Dr. Birdwell and Mr. Hartwell give me cause for concern. This language can be found in Section 4B of the agreement and reads, "The district, including the governing board, hereby releases, acquits, and forever discharges superintendent and her successors, agents, attorneys, and insurers from and with respect to any and all claims, wages, agreements, obligations, demands, and causes of action, known or unknown, suspected or unsuspected, through the date that the district executes this agreement, including, without limitation, all such claims arising out of or in any way connected with superintendent's employment relationship with the district. To put it simply, until we know the extent of any possible wrongdoing and all of the facts, I am not comfortable asking taxpayers to possibly forego restitution to the district. I truly understand the desire of many to quickly resolve these matters. I also understand the community feels betrayed. Yes, there are many compelling reasons to settle. However, I would prefer to keep the restitution option open before closing this unfortunate chapter in the district's history. My vote is no.
Board Member Hartman?
I did hear that restitution is still open, but.
And I heard that it's not necessarily.
Okay, so, yeah, this is an emotional, financial, and practical decision. From a personal standpoint, it's pretty distasteful. It's unpleasant, and I personally feel betrayed and misled in some circumstances. But that is what it is, and I'm sure many people feel that way. Teachers, community members, many people. So sometimes it's hard to get beyond that point. However, my job isn't to make this a personal decision. It's about what's best for this district, what's best for this community, and most importantly, what's best for our students. And for those reasons, Mr. Sands outlined the financial implications on this pretty well. From a financial standpoint, it makes sense to move on. Some people say cut your losses. There's potential risk of well over another $500,000 that I'm not willing to put this district at risk, because that's equivalent to another 10 teachers in this district and our students. It's not a risk I'm willing to take. Most importantly, there's practical implications here. And from a practical standpoint, our mission is to our students, to educate every student every day. And the sooner we can do that, and the sooner this administration, and as soon as our leadership at our schools, and as soon as our teachers can put this behind them, they can put their students first, which is the reason that I'm here, and I hope everyone else in this community in SUSD is here for that very same reason. And last, that reconciliation is not easy to make, but that's my rationale. I just like to make it very transparent. I'd also like to share that I have confidence in the teachers in this district, as well as the leadership, to move this forward, get it behind us, put the right leadership in place, and continue to do what's right and what's best for our students and for our teachers. So thank you.
Right, as that makes it my turn. First, I just want to say to my fellow board members, thank you for your thoughtfulness, your wisdom, and your leadership in this incredibly challenging process that we have had to go through. And I really can't imagine going through this all with anyone better than my fellow board members. And I extend that gratitude to our staff, to our acting superintendent, of course, and all leadership, our principals and our teachers, who have all been incredible in keeping the focus where it needs to be. So my comment will be brief, but I don't want to insinuate in any way that this was a simple or easy decision. It is painful, and my personal emotions and feelings of disappointment are, to say the least, complex. But I do not have the luxury of allowing them to be factors in this decision tonight. The facts and considerations to be weighed are numerous, and Several are incredibly frustrating, to put it mildly, and concerning. But for me tonight, the scale tips to accepting this severance agreement in the best interest of the district. I do vote yes. And I agree with all of your sentiments that I hope our SUSD community can move forward with its focus on students. So, by my tally, the motion passes 4-1. We move to action item 4B, possible approval of severance agreement with Chief Business and Operations Officer, Mr. Hartwell. Are there any other questions or comments regarding this action item? No? All right. I will make a motion that we approve the severance agreement with the Chief Business and Operations Officer as presented. Do I have a second?
Second.
Thank you, Board Member Kravitz. All in favor?
Aye.
Aye.
Aye. All opposed?
Nay.
Motion passes 4-1. All right, that brings us now, since that motion has passed, we can in fact go into agenda item 5, information discussion for 5A, interim superintendent and superintendent search, including the process, quality audit, community input, and timeline. Ms. Marshall, would you like to begin this conversation for us?
Madam President, members of the board, now that you have voted to end the employment relationship with the current superintendent, you have the opportunity to discuss potential search for an interim and/or a permanent superintendent. There are several options available to you. This item was placed on the agenda in the event that you did vote to approve the severance agreement so that you could talk about everything from timing to community input to what process you'd like to see. And so I will, with that introduction, let you have a discussion, and I'll be here for any questions about those issues that I might be able to answer.
Thank you. Do we have any specific questions at this time? I know, oh, sorry. Oh, Board Member Hartman.
Well, two sets of questions. One is the procurement process and timing, and the second is community involvement. I think those, for procurement process, what is it that we need to do next? How do we move this forward?
So the procurement process you would use if you choose to employ a search firm to assist the board in finding either an interim or a permanent or both. That timeline, the quickest that typically happens is about 6 weeks. You currently have an acting superintendent in place, so you could take the time to do that RFP for our purchasing department has done it before in terms of a scope of services. They could update the scope of services that they have to explain what we're looking for in terms of assistance with the district, for assistance to the district for a superintendent search, including finding candidates. The search firms often will facilitate community forums, or you can choose to do those yourself. But the general process takes about 6 weeks to secure a search firm if that's what you choose to do.
Okay. And so we can start that as soon as, I guess probably our next scheduled meeting. Or can we do that? Can we
If I
actually do that?
get
Is that an
feedback-
action item today?
No,
That's
this is not an
discussion
item.
It's
This
not
is
an
purely
action item,
discussion.
but if I get feedback that that's the interest, I can certainly talk to our purchasing department and get the ball rolling on that.
Okay, I would definitely have interest there. And then, how long have you been here?
10 years.
10 years, okay. So we have some experience in hiring superintendents, going through processes. I'm familiar with blue ribbon committees and community really, we called it Blue Ribbon Committees in the past, and there may have been other forms. So my question really is open-ended to you. Is there a process that you've seen that has worked well in this district over the years, with the goals being kind of inclusive input so that the community can participate in an engaged way in the selection process?
From my perspective, the process that we have used in the past of going to each learning community and inviting the public to come to submit online, to email us, to give us what do they want to see, to come down and talk to us, to gather all that input and make sure that everybody on the board understands what we're hearing from the public, and then actually going out to the public and talking with people. I found that to provide the most comfort to the community that they are seeing what we're trying to do, and that they have a say, and that they're being heard.
So to that point then, I am in support of moving forward with an RFP through procurement as soon as possible. I would like to see an additional item in the RFP as to experience, specifically their experience and best practices in collecting community support. It would be helpful to understand where some, successful practices and ideas as well. Thank you.
And I should correct myself, you would need to approve the issuance of an RFP, but I can go ahead and talk to purchasing about putting together a package in preparation for that. So you could do that as early as April 12th.
Okay, thank you.
Board Member Kravitz?
I just wanted to clarify with Mrs. Hartman. Are you mentioning an RFP for an interim, for an interim or for permanent?
Actually, that's a really good point. I would potentially both.
Well, okay, because the reason I ask is because for interim, is it not possible to use, to try and identify somebody through EIS or Smart Schools, which would?
Yes, both ESI and Smart Schools are what we call leased employee companies.
Right.
We have a current contract with ESI. We could certainly reach out to companies like that and ask what kind of candidates they have already interested in superintendent positions.
So for what could conceivably be a short-term stint to try and get somebody in that position as soon as possible, just to keep the operations moving in our district, that is another option, rather than taking 6 weeks for an RFP.
You
for the
could
whole RFP
you could
process.
certainly do that, and one of the benefits to that is that we are not in the sweet spot, so to speak, for going out for a permanent superintendent search, given that it's April. I know that search firms in the past have suggested much earlier in the calendar year to start such a search, so that might be a reason for you to use a shorter term process for an interim to allow you a longer term process for a permanent.
Board Member Hartman?
Just to
have a
follow up, so to Board Member Kravitz's comment, is it possible to run these parallel so that we can get potentially a short-term and run a?
Yes, you could do
Okay,
both.
great.
Okay, Board Member Kirby?
Okay, so I agree with the permanent search process. With respect to the interim, I am comfortable with the EIS or whatever. But could we
ESI.
also, in addition to that, or are these mutually exclusive, could we simply post a position for interim superintendent to see, and post it even nationally, to see what kind of feedback, what kind of interest we have, in addition to those other organizations?
We absolutely could post it ourselves nationally, in addition to asking companies like ESI what they have to offer in terms of candidates. We could do both.
Because then we get a wider net.
Yes.
Board Member Beckham?
I would also like to know that, I realize that this district has done this several times in the last 10, 15 years. And I wonder if we could have, who we have used as a search company in the past, so that we can have record of that. I would also, with all the changes that are being done with companies and searching and just technology, I wonder if there are some other search companies out there that we have never used in the past, that we've, at the district, we tend to probably go to the same people that are available. And we may want to look at some of the best schools in this country and find out who they have used in the past or where they got their superintendents.
But
So I'd like to look at the side of the box and do just a little bit more research than our typical, look, we've used these in the past, let's use them again.
okay.
Board Member Kirby,
I
I
don't
think
dis-
I know what you're going to ask.
Yeah, I don't disagree, but wouldn't the RFQ or RFP process take care of that? And if we go start asking people to apply, that's,
I'm not asking them to apply, whatever the process is, I don't want to have come back with the same group of research companies that we have used. We may pick one of those, but not look outside that with all the changes that have been
So-
happening in this
so what-
country with school districts and with companies.
So what our
all I'm
purchasing
asking.
department does in general is they invite all comers to submit their name to different, to lists for different services. So they will have already some people who just a long time ago said, we're interested when you ever want to use a search firm. In addition to that, they can then put out the RFP and cast a wide net and let others know. They have an advertising process and all of that, and let other companies that might not already be on our lists know that we're currently looking for a search firm. I don't know all the details, but they advertise in things like the Arizona Capital Times, and then they have national publications that they use also.
So what I'm hearing is that as a procurement area, we cannot go out and say, hear about or talk to other districts to find out who they use and then send a request out to those specific companies. We're not able to do that because of state law or regulations.
I would not recommend contacting specific vendors and saying you should apply to make sure that we have a fair process. But the advertising for the RFP, I will talk to our purchasing to make sure that it is as broad as possible, maybe broader than what they normally would do, to make sure that we are letting people know across the country, companies know across the country that we're interested in that service.
Okay, thank you.
Neither. I'm just going to say, thank you for that clarification.
Sure.
Because I understand what you were saying. Yeah, we can't go out and start handpicking who we want to apply. And
Right.
Right, and that's
So
not what
that's-
the
yeah.
intent was.
So-
but
I understand.
how
Okay.
that can be confused.
So, so I'd like to just say that, I mean, I've heard three options that this board has in front of it. And considering timing, we definitely don't want to set aside the idea of an ESI, because yes, this interim role could actually be a quite long one, a long term, if we really are going to be in the right timing for a permanent search. Plus, I agree, whichever board member said that, I mean, to really get our community input, to really get our arms around where we want to go, that's a long process as well. So I heard, obviously kind of a procurement of a search firm, but also the possibility of an ESI or some type of, now you said, we have a contract with ESI, but smart schools might be another option.
Right.
What is the process for working with them? Like, what would we need to do if we wanted to look into them as well?
With smart schools?
With smart schools, yes.
I would have to look into that.
Okay.
I'm not sure I can give you an answer right now.
Fair enough. Definitely like to look into it. And then we have the other option of a posting ourselves. So at this time, I mean, obviously, this is just kind of our first stab at this discussion. Obviously have more. What would be your recommendation as far as the timing of when we want to come back as board and be able to really take a look at these three options in front of us? Talk about what a posting might look like, talk about what ESI and maybe Smart Schools has to offer, and also a procurement. What's our time frame realistically to have a productive conversation?
I would say the sooner the better.
Okay.
Your next scheduled meeting is the 12th. I think we can have a lot more information at that time for you.
Okay.
And I can, like I said, work with our purchasing department and work on an agenda item for you for the 12th. It is a work study, so you might also want to sort of replicate that or continue talking at a regular meeting so that more of your constituents can participate and comment on what you're doing.
Okay.
All right, Board Member Kirby?
So two thoughts are coming to mind. First is, and maybe this is what could happen on the 12th, is a conversation around what we're looking for, what the skills, qualifications, and attributes of the candidate. Because let's, quite honestly, I've read the CFO posting that's on, and I think we can greatly improve the sophistication of our job postings. And I think we might as well start with the superintendent, or the interim superintendent. And secondly, is it possible at a work study to agendicize like a call to the public or something that allows for public comment at that work study, and specifically to hear from the community what attributes are they looking for? There are some that feel we need to go national. There's some that strongly believe that we need someone who knows Arizona statute, right?
Right.
And those are all considerations that I'd like to hear. So I would, definitely with the permanent, that long community involvement, but also for the interim, I would like to get some public comment on the attributes they're looking for.
And we can certainly add public comment to your work study on the 12th. We don't normally have public comment on work studies, but we can certainly choose to add that.
Can we add those that's specifically on that topic, like a call to the public specifically on?
No, the only circumstances under which you can say it's got to be about this is when it's a statutorily required hearing on something.
Okay.
In public comment, anybody can say whatever
like
they
the-
want as long as it's not profane or,
So
so
it's-
we could certainly say that that's what we're interested in hearing, but people can come to the mic and say
Okay.
what they like.
All right, fair enough.
To
Board Member
follow up
Beckham?
on that, if that isn't, can we do a specific town hall or something?
You can do that.
If we want to do it by complex or, I don't know how many people are
Take a
going to
long time.
come, but you could try one big one, see how
Or-
many people are willing to come, and we could have something online too.
Well, could
You can do that.
Board Member Kirby?
Could we have a town hall on the 12th, start with that, and then listen to the public, listen to the comments, and then move into the work study, where
that we could
we
discuss it.
discuss it and develop the posting? And
Yeah,
give
you can do
feedback
that.
of, you can tell ESI or Smart Schools, this is the kind of person we're looking for. Could we do that?
You can. We can do that.
I'm up for
Definitely
public
consider
comment.
that. We'll definitely take a look at the 12th's agenda
Okay.
and look at our time frame, and then consider how long we want to allow for that town hall, if we're going to put a limit on it, or we're there until it's over.
There until
That would be a discussion, or consideration, at least, for the board to,
I don't remember
Make-
what time that's currently scheduled for.
3, I
3 o'clock,
assume.
so.
Yeah. That's obviously another consideration as far as our community. They prefer something in the evening
Maybe it's
as
afterwards.
opposed to
Well,
noon or before a 3 o'clock work study.
the only thing about putting it afterwards is we would have the conversation of what we're looking for before we've heard from the community. So I believe it definitely needs to be before, but there's nothing to say that we start at, I suspect that there's going to be quite a bit of public comment. And so we could start at 3, 3:30, 4 o'clock, and I'm fairly confident we'll go beyond
Right.
5.
Well, let me ask you this, if we have regular board business, and we start that at 3, and we get through that, and then within the agenda, we have a town hall, we listen, and then our discussion
do that.
follows after that.
That sounds like us.
If we can do that.
Is that
Good
a
idea.
possibility?
You can do that. Again, if somebody wants to come to the mic for a public comment kind of thing and say something that's not on topic, that's okay.
That's okay.
But you can do it that way, yes.
That's all right.
Yeah.
They'll stick out, but that's okay. All right, so I guess we'll work on that type of agenda if that sounds appropriate to the board, direction.
Okay, thank you.
Excellent. Any other
Sir.
questions or comments? Move us forward before then. No? All right, thank you very much. Thank you all. All right.
Is it appropriate now for public comment?
No, I'm afraid now, no, we have no public comment on our agenda tonight, so we can't take comment from the audience. So sorry.
All right.
All
But you
right.
can email us.
Of course. And so, do I have a motion to adjourn our meeting?
So moved.
Thank you, Board Member Kirby. Do I have a second?
Second.
Thank you, Board Member Kravitz. All in favor?
Aye.
Aye. Motion passes 5-0. Thank you all. We are adjourned.
Yeah, you have good conference.